welcome to the Deep Dive. This is where we really get stuck into some complex, often future-focused source material and try to break it down into the knowledge you need today.
That's right.
And today, we're definitely stepping into the future. We're looking at jurisprudence, the intersection of artificial intelligence, AI, and the massive machinery of our legal systems.
Yeah, and it's not just theory anymore, is it? It's happening now. The pace of change is, frankly, astonishing. It's genuinely revolutionizing how justice is delivered or even sought.
It really is. And our deep dive today, it's grounded in some incredibly detailed insights from Mr. Zaheer Ahmad Meer.
Ah, yes. He's got such a unique viewpoint.
Yeah.
A constitutional and corporate lawyer, but also an author focused on the future, founder of the Digital Future AI School.
Exactly. So he really understands both sides, let's say, the rigidity of established law and the sheer disruptive power of this new tech.
That dual perspective is invaluable here.
Absolutely.
Yeah.
And the picture he paints for us, it's so vivid. Imagine you walk into a courtroom,
Yeah.
not in 50 years, maybe much sooner.
Right.
And there are no stacks of dusty law books, no frantic clerk digging through files. Instead, you've got an AI clerk, maybe just a screen, that's already summarized every single argument, every counter-argument. A digital judge, or maybe an assistant to the judge, that could pull up every relevant precedent, every statute in like a microsecond.
Finding the law at the speed of light, that's the vision.
That's the vision. But, and this is the big but that kicks off our mission today, can faster justice also mean fairer justice?
That's the fundamental tension, isn't it? Because speed is one thing, accuracy, efficiency, great. But fairness, equity, that's another dimension entirely. When you crank up the speed of the system, you have to be incredibly careful about where it's actually heading.
That's the core issue we need to unpack. We're going to explore the 4 key insights Mr. Meer puts forward. We'll start with the practical stuff, AI as a judicial assistant, but we'll go all the way to the really critical philosophical and ethical lines we have to draw.
And to really hammer home what's at stake, we have to start with this incredible story, an anecdote from the Lahore High Court that just perfectly encapsulates the whole debate.
Okay, this was a pilot project, right? Testing out AI in a real-world court setting.
Exactly, a pilot program, deploying an advanced AI assistant to directly support the judges. And the task they gave it, well, it was the kind of administrative nightmare that honestly bogs down so many courts. Reading and analyzing case history.
The backlog stuff.
Yeah.
The really time-consuming part.
Precisely. Specifically, the machine had to consume volumes of case law. Not just summaries, not just briefs, but the entirety of relevant historical judgments. And get this, do it overnight.
Overnight. We're talking potentially thousands, maybe tens of thousands of pages. Dense, technical, legal text.
Yep. The kind of work that, traditionally takes a whole team, paralegals, junior lawyers, weeks, maybe even months to properly sift through, analyze, connect the dots.
Okay, so what happened?
Well, the result was pretty astonishing. By the next morning, the AI had done it. It produced these concise, perfectly referenced, flawlessly brief summaries for the judges.
Wow.
Yeah. The lawyers, the judicial staff who were there, apparently they were just stunned, silent. It proved, beyond any doubt, that AI can handle this massive data burden. It can clear away the logistical logjam that plagues modern law.
That's genuinely impressive. A huge leap in efficiency.
Huge. But then, almost immediately, that wow moment, that technological marvel, it kind of soured a bit. It turned into this deeper, almost existential question.
Okay.
Because one of the lawyers there watching this machine basically do the foundational work, the kind of stuff they cut their teeth on, they asked the critical question. They said, if the machine finds the law, what becomes of our reasoning?
Ah, right.
Yeah.
If the grunt work that builds understanding is gone,
Yeah.
what happens to the understanding itself?
Exactly. And that question, that's the anchor for our whole deep dive today. It captures that central conflict perfectly. AI does the logistics, the data sifting, the history, the citation matching, all the tedious stuff. But if the human element, that capacity for critical legal reasoning, for interpretation, for moral judgment, if that gets diminished or sidelined by the automation, have we actually gained anything? Have we lost something vital?
It's about finding the balance. We need to understand what that balance looks like.
Which takes us straight into our first core insight, AI as the essential judicial assistant.
Okay, core insight 1, AI augmenting the judiciary. So we're moving beyond just like fancy word processors or electronic filing systems here.
Way beyond. This is about tackling the sheer cognitive load, the legal grind, as the source material implies, freeing up judges and legal professionals to focus on the higher order thinking.
Right. Because when you think about a judge's day or a lawyer's day,
Yeah.
a lot of it isn't lofty debate, is it? It's managing information.
An enormous amount, mountains of paper, endless digital files. We're talking about these huge repetitive tasks in, say, 3 main areas. First, just exhaustive legal research, finding the right precedents.
Which can be like finding needles in haystacks.
Exactly. Second, summarizing and synthesizing all that research once you found it, making sense of it. And third, meticulous citation management, cross-referencing, making sure everything is doctrinally sound. It's painstaking.
And it's work that, while maybe not intellectually thrilling, is absolutely essential, right? You can't just skip the research step. A ruling has to be grounded.
Absolutely non-negotiable for a decision to be valid, defensible. And the source material, it really highlights how AI automates this entire tedious process.
The speed difference alone, like in that Lahore example, it's just revolutionary. Reading volumes overnight versus weeks of human effort.
It's a step change. And let's look a bit closer at the tasks. We're talking electronic discovery, e-discovery. Imagine sifting through terabytes of emails, documents, messages.
Yeah, finding keywords, relevant chats, flagging privileged stuff.
Right. AI can do that incredibly fast, a process that historically could cost law firms, hundreds of thousands of dollars, thousands of human hours. AI just crunches through it.
So it's not just reading old cases, it's managing the whole administrative guts of litigation. Okay, but here's a potential catch, maybe circling back to that lawyer's question. Traditionally, isn't doing that painful, exhaustive research the grind, how junior lawyers and clerks really learn the law, like deep down, if you take that away?
That's a really good point. Are we losing that foundational understanding, that sort of institutional legal muscle memory?
Yeah. Are we sacrificing training for efficiency?
It's a valid concern, and it connects directly back to that worry about reasoning. The perspective from the source, though, suggests the intellectual work doesn't disappear, it shifts.
Shifts how?
The AI takes over the burden of locating the information, finding the right precedent. The human's focus shifts to applying it. The big human gain that's cited is freeing judges to dedicate their mental energy, their focus, intensely to interpretation and equity.
Okay, let's drill into that. What does interpretation really mean when the AI has already served up the top 3 most relevant Supreme Court cases on a platter? What's the judge's main intellectual task then?
Well, the task that remains is fundamentally human, isn't it? The judge stops being a sort of super librarian hunting for the right book.
Right.
And becomes the expert who has to weigh the specific, messy human facts of the current case against the spirit and the intention of the law, the precedent the machine found.
So dealing with the nuances, the conflicting evidence, the emotional context, stuff a machine wouldn't necessarily grasp.
Exactly. Grappling with the unique facts of this case, these people, and ensuring that applying the law as found by the AI actually results in true equity in this specific situation. That's the core interpretive act.
So the AI builds the legal scaffolding, finds the relevant rules, and the judge's time is now freed up for the ethical side, considering mitigating factors, judging witness credibility, understanding the real-world impact of a ruling on people's lives, on society.
Precisely. The focus shifts from information retrieval to synthesizing human context. The aha moment here, really, for you listening, is that AI isn't about replacing the expert judge. It's about optimizing their function.
Letting them be better judges.
By removing the administrative drag. It allows them to truly focus on judgment, empathy, compassion, these uniquely human, non-computable skills. That's the promise.
Okay. AI lifts the burden so judges can focus on the deeper, more thoughtful aspects of justice. That sounds pretty good. That's the ideal scenario for judicial assistance.
It is.
But once the machine gets so good at finding the law, at synthesizing data, the logical next step, maybe the scariest one, is letting it predict the outcome.
Yes.
And that takes us right into core insight, too, predictive power.
And this is really the moment we shift gears, isn't it? From AI as a helpful tool, maybe like a super paralegal, to AI as a potential oracle. A biased oracle, perhaps. We move from organizing information to forecasting outcomes. And this, the introduction of predictive analytics into litigation, is arguably the most controversial use of AI in law, period.
Okay, so how does that even work? Law seems so complex, so human, a machine can't, like, read a jury or sense if a witness is lying or appreciate a clever legal argument, how could it possibly predict a verdict?
Well, it doesn't work by understanding human nuance. Not at all. The mechanism is purely statistical. It relies entirely on pattern recognition, learned from massive amounts of historical data.
So past cases.
Millions of them, past judgments, sentences, plea deals, settlements. The AI ingests all of it, and it looks for correlations, statistical links between countless factors: the court jurisdiction, the specific charge, maybe the judge who presided historically, the demographics of the people involved, prior records, lawyer assignments, and, crucially, the final outcome of those past cases.
And based on all those historical patterns.
It generates a probability score. It forecasts the likely outcome for a new case that has similar data points, similar inputs. Cases like this, in this court, with these factors, historically resolved this way X% of the time.
Okay, I can immediately see how that could be a powerful tool, especially before trial, maybe for deciding whether to settle a case or fight it out, for managing risk.
Absolutely. It's potentially very potent, but the source material is extremely careful here. It highlights that this predictive capability has a dual use. There's an ethical, beneficial way to use it,
Right.
and there's a deeply careless, potentially harmful way.
Okay, let's unpack that. What's the ethical side, the good use case?
The ethical use case is primarily about facilitating settlement. Imagine, say, two companies locked in a bitter contract dispute. Emotions are high. Maybe both sides think they're 100% right.
Standard situation.
Right. Now, introduce an AI that objectively analyzes the case facts, the relevant precedents, the jurisdiction's history, and it comes back and says, look, historically, given these specific factors, Party A has about an 80% chance of winning if this goes to trial.
Ah, so it injects hard data into what's often a very emotional, sometimes strategically bluffed negotiation.
Precisely. It provides an objective, data-driven risk assessment, and that can be a powerful catalyst for settlement. Suddenly, both sides see the statistical odds, they see the risk, the potential cost of going to trial and losing. It encourages them to find a fair, negotiated resolution outside the courtroom.
Which saves time, money, court resources.
Huge savings. It clears court dockets, reduces the burden on the system. When used purely as a neutral assessment tool for negotiation, it's arguably a massive public good.
Okay, that makes sense. Assessment for settlement, that's the ethical link. Now, the flip side, the careless use. The source warns this tech could perpetuate, even magnify, bias in the justice system. How? Why does that risk exist?
The risk is fundamental to how machine learning works. It's the classic problem. Garbage in, garbage out. Or maybe, more accurately here, bias in, bias out.
Because the AI learns from past human judgments.
Exactly. It's trained on historical data. And if that historical data, those past rulings, those past sentences, contains patterns of systemic bias, well, the AI learns those patterns too.
For example, if, historically, certain demographic groups maybe received harsher sentences for similar crimes compared to others due to factors that shouldn't be relevant legally.
Right. Due to historical prejudice, socioeconomic factors, implicit bias, whatever the reason. If those biases are reflected in the patterns of past judgments, the AI will identify that pattern. It will learn that correlation, and it will treat it as a predictive variable.
And the machine. It doesn't have a conscience. It doesn't stop and ask, wait, was that historical pattern actually fair?
Not at all. It just sees a strong statistical link. Factor X correlates with outcome Y, and it uses that correlation to make future predictions. Its goal is mathematical accuracy based on the data it was given, not philosophical fairness.
So it essentially learns our past mistakes or institutional errors.
Precisely. It learns the biases embedded in the history of the system. So if you then deploy that AI to forecast outcomes, or worse, to help make critical decisions like setting bail amounts or recommending sentences.
You risk baking those historical injustices right into the future, making them seem objective, mathematical.
You risk ossifying them, turning past social wrongs into mathematically validated truth. The AI reinforces the distortion. It makes the system incredibly efficient at delivering historically skewed results.
Wow, okay. So the speed and efficiency gains become almost irrelevant, or even dangerous, if the justice is being delivered as fundamentally unfair because of biased data.
That's the heart of the danger. The speed is meaningless if the direction is wrong.
This raises a huge challenge, doesn't it? It means we can't really use these powerful predictive tools ethically unless we first go back and rigorously audit and maybe try to clean up the historical data we're feeding them.
It forces a reckoning. The technology itself demands we take a hard, honest look at our own past judicial performance, a kind of radical moral inventory.
Because technological efficiency can never be the primary goal, can it? Not when we're dealing with people's freedom, their rights, their lives.
Exactly. Moral purpose has to come first. Always.
Assuming we can navigate those immense risks, Core Insight 3 suggests technology isn't just changing how courts operate internally, but also changing the very nature of legal agreements themselves and how justice is delivered procedurally.
Yeah, we're moving into structural changes now.
Right.
Right. This next part looks at how the tech is changing the very structure of legal obligations and court processes. We're talking about smart contracts embedding enforceability directly into digital agreements, and then how digital courts are streamlining the procedural side of justice.
Okay, smart contract and blockchain. People hear these terms, but let's clarify the connection for our listeners. How does a contract get smart? And why is blockchain important for the legal side?
Okay, so a smart contract, fundamentally, it's an agreement where the terms are written directly into computer code.
Instead of just on paper.
Exactly. And this code lives on a blockchain, a decentralized distributed ledger. Now, the blockchain part is key for integrity. It provides immutability, meaning once the contract code is deployed, it's incredibly difficult for any single party to tamper with or change it arbitrarily. And it provides transparency.
So the code itself effectively is the binding agreement, locked and visible.
Pretty much. The code is the law of that specific contract. And the smart part, that means the contract executes itself automatically when certain predefined conditions written into the code are met and verified.
Okay. So give me an example.
Sure. Imagine a contract says, when commodity X reaches price Y, then payment Z is automatically transferred from party A to party B.
Right.
If that's a smart contract, once the condition, price Y being reached, is verifiably met, the payment transfer happens automatically. No need for party A to initiate it, no need for party B to chase it, no need for lawyers or courts to enforce that specific clause.
The code just does it. It enforces itself.
That's the core idea. And the implication is it could massively reduce what we call transactional friction. Think about commercial deals, logistics, supply chain tracking. Anywhere agreements involve clear, verifiable conditions.
It cuts out the middleman, cuts out delays, cuts out arguments about whether the condition was met if it's clearly verifiable.
Exactly. It significantly reduces counterparty risk, the risk the other side won't hold up their end. And it could potentially eliminate the need for court action for a whole swath of simple, conditional, contractual disputes. The law is baked right into the tech.
Okay, but wait. You said verifiably met. How does the code sitting on a blockchain know what's happening in the real world? Like, how does it know the price of wheat actually hit $5 or that a shipment really arrived?
That's a crucial technical piece and a potential point of legal contention itself. It relies on things called oracles.
Oracles, like crystal balls.
Not quite. Think of oracles as trusted, secure data feeds that bridge the gap between the blockchain and the real world. They verify real-world events, a price feed from a reputable exchange, a GPS signal confirming delivery, sensor data from a container, and they feed that verified information into the blockchain in a secure way that the smart contract can trust and react to.
So the whole system hinges on the reliability and security of these Oracle data feeds.
Absolutely. The legal integrity of the smart contract often depends critically on the trustworthiness of its oracles. It actually creates a whole new area for potential legal scrutiny and dispute challenging the data source.
Interesting. So it solves some problems, but maybe creates new technical legal challenges.
Okay.
That's smart contracts. Now, shifting gears slightly to the digital courtroom. We've all done Zoom calls, maybe even Zoom court appearances during the pandemic. But the source suggests the benefits go way deeper than just convenience.
Oh yeah, it's about a full procedural overhaul, really aiming for judicial optimization. The source material details the massive potential for reducing delay. Just think about the bottlenecks in a traditional court system.
Scheduling nightmares?
Right, getting judges, lawyers, witnesses, courtrooms all physically available at the same time. Then there's the sheer volume of paper management, which is inherently slow. And travel time lawyers, parties, witnesses traveling to court. It all eats up time and resources.
Virtual hearings, digital filings. They obviously cut out a lot of that physical friction. But are we seeing actual measurable improvements in systems that have gone digital?
Yes. The reports indicate real optimization in case flow management. For instance, simpler hearings, procedural motions, arguments about document submissions, scheduling conferences. These can often be handled much faster, sometimes even asynchronously, online.
Meaning, not everyone needs to be logged in at the exact same moment.
Potentially, yeah. Or just handled in quick virtual sessions. This frees up the physical courtrooms and the judge's most valuable in-person time for the really complex stuff, the full trials, the cases needing extensive live witness testimony, jury deliberation. It allows for better resource allocation.
Right, focusing the intensive resources where they're most needed.
Yeah.
And the source also highlights a major ethical benefit, especially maybe in places struggling with corruption or transparency issues.
This is a really profound point. Digitalization, moving processes online, inherently increases transparency. It creates clear, often immutable audit trails.
How so?
Well, when every filing, every piece of evidence submitted, every procedural request and ruling is digitized, logged, timestamped, perhaps even on a secure ledger, it becomes vastly harder for records to be manipulated, backdated, or for illicit side deals to happen unnoticed.
It cuts down on the off-the-record, face-to-face opportunities for, let's say, improper influence.
Exactly. It doesn't eliminate the possibility entirely, of course, but it makes it significantly harder and riskier. Digitalization doesn't just make the process potentially faster, it can make it inherently cleaner, more accountable. The system itself leaves a digital footprint for almost every action.
And that verifiable accountability, that trail,
Yeah.
that must be crucial for building public trust, especially if it's been eroded.
Absolutely essential. It's a key component.
So these aren't just ideas on a whiteboard. Smart contracts, digital courts, they're actually being implemented now.
They are indeed. Which leads us nicely into Section 4, where we look at some real-world professional examples of this technology in action globally.
Yeah, it's really important to stress this isn't just, futuristic speculation anymore. The AI assistant we talked about, smart contracts, digital court procedures,
Yeah.
these are active components right now in some leading judicial systems around the world. This is current policy development. Okay, so let's look at the examples cited in the source. It mentions the Dubai Court of Future and the Singapore Smart Courts as international leaders. What are they actually doing? What does it look like on the ground?
Well, they're focusing heavily on those foundational practical applications we discussed in Core Insight 1, really streamlining the logistics. So both Dubai and Singapore are using AI extensively for things like advanced e-filing systems, making it easier and faster to submit documents, and sophisticated legal research platforms for judges and court staff.
Getting the basics right first.
Exactly. Singapore in particular has been quite advanced in using machine learning algorithms for things like case classification and resource allocation.
Case classification, what does that mean in practice?
It means using AI to automatically analyze incoming lawsuits or filings based on the content, the legal area, keywords, complexity indicators. The AI categorizes the case.
Okay, and why is that useful?
It allows the court administration to be much more efficient. They can quickly route the case to a judge who has specific expertise in that area, for example. Or they can better forecast how much court time or judicial resource this type of case typically requires, which helps with managing the docket and scheduling.
So it prevents bottlenecks, stops complex cases getting stuck with the wrong judge, or simple cases taking up too much time.
That's the goal. It's essentially applying smart business efficiency principles to court management, strategic deployment of resources.
So Dubai and Singapore are really focused on building that solid digital infrastructure, the practical stuff, before maybe diving headfirst into the more controversial areas like AI predicting sentences.
Right. They seem to be building a reliable digital bedrock first, which makes sense. And then the source takes a really interesting turn, looking at emerging implementations, specifically mentioning efforts within the Pakistan Judicial Policy Board.
Okay, Pakistan. What are they exploring? Especially given, the complexities of a system that might operate in multiple languages.
That's a key point. The Judicial Policy Board there is reportedly focusing on two main types of modules. First, again, is advanced record analysis dealing with the sheer volume of historical case data, the backlog issue that plagues so many established legal systems, getting a handle on the data.
Right, the efficiency piece again.
But the second module mentioned is really fascinating and touches directly on equity, the translation of judgments. Specifically, translating judgments from English, which is often the language of the higher courts, into Urdu and potentially other regional languages.
Ah, translation. It sounds logistical, but you're saying it's about equity. Why is translating a judgment so critical for fairness?
Because fundamentally, access to information is a prerequisite for justice, isn't it? If you can't understand the reasoning behind a decision that affects your life, how can the system be truly fair to you?
Right. In many places, the official court language might be English or another colonial language, but that might not be the first language or even a fluent language for many citizens, many litigants.
Exactly. So if a judgment comes down only in, say, English, a person who doesn't understand English fluently can't grasp why they won or lost, what the implications are, what their rights are moving forward. Not without immediately having to pay someone else, another professional, just to interpret the basic ruling.
It creates an immediate barrier, a cost barrier, an understanding barrier. It adds another layer of expensive complexity just to know what happened in your own case.
Correct. So, by developing AI-powered translation tools, the technology serves a profoundly democratizing function. It aims to make the court's reasoning immediately understandable, accessible to all citizens involved, regardless of their fluency in the primary administrative language of the court.
That's powerful. And this isn't just like Google Translate for legal documents, is it? Legal language is incredibly precise, context dependent.
Oh, absolutely not. It requires highly sophisticated natural language processing NLP systems. These systems need to be trained specifically on legal terminology, legal syntax, regional legal customs and conventions, to ensure the translation isn't just literal, but maintains the precise legal meaning and the intended force of the original judgment.
So getting the nuances right is critical.
Critical. This commitment to high-quality legal translation shows AI being used directly to tackle institutional inequality. It's about making justice not just faster, but genuinely more accessible and understandable for everyone.
That really is a remarkable use case. It perfectly ties together the themes of speed, efficiency, and that core goal of equity.
It does.
But whether we're talking about translating judgments accurately, or predicting settlements fairly, or even just summarizing case law efficiently, we keep circling back to that fundamental boundary, the human element, which brings us squarely to core insight 4, the ethical limits and the non-negotiable role of human conscience.
And this really is the bottom line in the source material. Its definitive, absolutely non-negotiable conclusion. We've seen AI do incredible things, analyze data at superhuman speed, automate complex tasks.
Yeah, the potential is huge.
Huge. But Mr. Meer's analysis and the consensus in this area is crystal clear. AI can assist, it can inform, it can optimize processes, but it must never be allowed to make the final decision, the final verdict.
Never. Full stop. The human judge, the human decision maker, must remain in control. Period.
Yes, and the source is emphatic about why. It comes down to this core belief. Human conscience is the soul of justice. Without that conscience, that human element, the legal system risks becoming just a mechanism, a cold process for producing outcomes rather than a framework for achieving actual justice.
Okay, let's break that down. Human conscience. What specific elements does a human bring to a courtroom that an algorithm, even a really sophisticated one, a trillion-parameter AI, simply cannot possess? What are the non-computable factors?
Well, the key non-computable factors are things like empathy, the ability to truly consider mitigating circumstances in a unique context and understanding the broader moral landscape.
Right.
An algorithm excels at pattern recognition, right? At calculating probabilities based on data points it's seen before. It can tell you statistically 80% of people with profile X reoffend with crime Y.
It sees the data point.
It sees the statistic, but it cannot feel the weight of sentencing, say, a first-time offender whose life circumstances are completely unique and perhaps tragic. It can't truly weigh the conflicting moral rights and human emotions in a really sensitive family law dispute.
So the AI sees the statistical category, the pattern. But the human judge has to see the individual person, the individual life story behind the data.
That's the fundamental divergence. Real equity, true justice, often requires moral judgment. And moral judgment isn't just calculation. It's an inherently philosophical act. It demands compassion, contextual awareness, maybe even wisdom.
Things that are hard to quantify, let alone code.
Exactly. If you remove that human conscience, that capacity for nuanced moral judgment, the system risks becoming, well, mercilessly efficient. It would just execute the statistically most likely outcome based on past data. It would ignore the potential need for mercy, for mitigation, for grappling with those messy, non-codified ethical dilemmas that define the most complex and human legal decisions.
That distinction calculation versus judgment seems absolutely critical. The source argues we lose the very soul of justice if we cross that line, if we let the machine make the final call.
Absolutely. And when we synthesize the final takeaways from Mr. Meer's work, the conclusions are really powerful, and they're clearly hierarchical. First, technology can speed things up, make justice delivery faster, more efficient, but it cannot replace the human element in judgment.
Okay. Speed, yes. Replacement, no.
Second, and this is presented as the governing principle, AI must always be a servant of the law, never its master.
Servant, not master. That concept of servant implies we need to actively design the systems to keep it that way, right? To prevent AI from sort of creeping towards taking over.
Precisely. That's a critical design challenge. We have to build these systems with clear, robust, easy-to-use human override capabilities. We need protocols ensuring that the final legal and moral responsibility for any judicial outcome rests squarely, undeniably, on the human judge or decision maker.
Because the danger is, if the AI systems become too complex, too opaque, like black boxes, even the judges don't fully understand.
Then we risk unintentionally handing over authority. If judges feel they can't challenge or question the machine's output easily, or if they overly rely on it because it's fast and seems authoritative, that's how mastery can creep in.
So it requires constant vigilance, an ongoing commitment to keeping the human in the loop and ultimately in charge.
Eternal vigilance, as they say. The power of AI is seductive. It offers seemingly quick, data-driven, objective answers. But that speed, that efficiency, must always be tethered to human moral guidance and ultimate human control.
It's about finding that crucial balance, isn't it?
It is. Speed without conscience gives you a cold, potentially cruel system. Conscience without speed means justice delayed is justice denied for countless people stuck in backlogs. The future of law, the court of the future, really lies at that precise intersection, harnessing technological efficiency while safeguarding unwavering human morality.
This has been a really fascinating journey, hasn't it? We've gone from the tedious grind of legal research all the way to these fundamental philosophical red lines about human conscience. And the sources, especially Mr. Meer's insights, seem clear. We can have faster, cleaner, maybe more accessible justice through AI.
But only
Only if that human element, that human conscience, stays firmly in the pilot seat.
right. The key takeaway isn't just adopt AI. It's adopt AI, thoughtfully, carefully, and rigorously define its boundaries before you deploy it widely in the justice system.
Which leads us perfectly into our final provocative thought. Something for you, our listener, to chew on as you think about these courts of the future. We started with that lawyer in Lahore, asking, if the machine finds the law, what becomes of our reasoning? Let's take that a step further. If AI handles all the research, drafts the summaries, maybe even identifies the key precedents, basically, if it automates the foundational legal spadework, reducing it to data processing, where and how will the next generation of lawyers, of judges, develop that deep, nuanced critical thinking, that genuine legal reasoning capacity?
That's a great question. If the intellectual heavy lifting, the stuff that traditionally builds legal intuition and analytical skill, is increasingly done by machines, what skills become paramount for humans?
Yeah, what do human legal professionals need to focus on cultivating? Is it ethical analysis, advanced logic, negotiation skills, persuasion, maybe even moral philosophy? How do they ensure they remain the masters of the law and not just, managers of the machine that serves up the answers?
What does legal training even look like in that future?
Something to definitely ponder as AI continues its own deep dive into our most fundamental human institutions. Till next time on The Deep Dive, keep digging.